Good morning, everyone. Welcome back to Business Law 1. Today we're going to be looking at Chapter 12, which involves legality. So we're going to be looking at, in terms of, the overall learning objectives, types of contracts and bargains that are deemed illegal and the effect that that illegality has on contracts. We'll look at how courts deal with these disputes, as well as some special circumstances where courts will enforce otherwise illegal contracts. It's a fairly short or abbreviated chapter, but it's very interesting in terms of some of the topics that come up. So we've talked about what's the requirements to enter into a contract. We mentioned how you have to have offer, acceptance, consideration. I briefly mentioned it has to have a legal purpose. The parties have to have contractual capacity, the ability to understand what they're entering into is a binding agreement. But an agreement is illegal either when its formation or its performance is a crime or a tort, or if it's contrary to some public policy. That's kind of like the standard kind of textbook definition. So illegality can embrace situations in a couple of different ways. So maybe there's an actual law, so it could be a federal, state, or local like statute, law, or ordinance that kind of prohibits certain types of conduct. Certainly anything that requires the commission of a tort, so that's where you're hiring someone to hurt someone else, either physically or to their property. That's not, you're not allowed to enter into those types of contracts. And obviously, if you do, and there's a dispute, you're not taking that to court. Contracts that are contrary to public policy. We live, here in Florida. We're very close to Cuba, which is 90 miles off the southern coast of Florida. And, for decades, Cuba had been a very close trading partner with the United States up until the late 1950s, early 1960s. And then when the Castro regime kind of took over, as a matter of public policy, we decided to isolate Cuba and, kind of put an embargo on them. And so, to this day, trade and travel is greatly restricted. And that's just a matter of public policy. And so, as the regime change occurred, decades ago, there certainly were plenty of companies in South Florida that had entered into contracts with Cuban counterpart companies. And, obviously, we're not going to enforce those contracts because that would be in violation of federal law. So that's that aspect of public policy. Contracts that are unconscionable, which we'll talk about that standard of what unconscionability means under the law. Normally, though, if we're trying to avoid hardship, there are some exceptions that can be provided. There's something referred to as like protection of one party. So, there may be something under, like, let's say, consumer protection statutes that we're going to say that consumers, even if they entered into something that they shouldn't have, we want to try and offer them some kind of protection. That's also this idea of, there's a Latin phrase, in pari delicto, which is, a reference to unequal guilt. So that, a party that has lesser guilt versus the party that has greater guilt or definitely should know better, meaning like a business, then we're going to say that, okay, even though this is illegal, we're going to enforce it based on the idea of consumer protection. So good faith and fairness, that really is kind of an implied kind of premise for every contract. The parties that enter into a contract, if you go buy a car this weekend and get it financed, if you go purchase a home, whatever it is you're purchasing, the law presumes that you and whoever the other party is, you're entering into it because you want to, and because you have every good faith in terms of your intentions to honor what you are agreeing to. Now, obviously, something could change 2 years from now. Maybe you lose your job, somebody passes away. I mean, things happen. But at the time the contract is entered into and executed, that's the premise. We're going to say that there's this idea of good faith and fairness. When we talk about unconscionable clauses, generally courts are not going to examine contracts to consider if they're fair or not. I mean, if you remember when we talked previously about like adequacy of consideration, courts don't want to dig too deep there. But when it comes to unconscionability, there's two levels that they can potentially look at. There's what is referred to as procedural unconscionability as well as substantive unconscionability. And so procedural unconscionability, sometimes those types of agreements are referred to as contracts of adhesion, and where that means that one party has really no ability to negotiate. That isn't necessarily going to void a contract. So think of like when you get in the mail an offer for like a credit card from, let's say, your bank or some other financial institution. It usually will say like, hey, you're pre-approved, and if you fill out this application, if assuming we give you the final approval, this is the interest rate. These are charges that you might incur depending on the type of transactions and your ability to pay. Um, you know, if you want that, you just fill it out and mail it in. There's no room to negotiate there. So I can't, if I get a credit card application in the mail from a bank, I'm not going to say, well, I don't really want 24.99 APR interest. I want to have 0% interest for the first 10 years, and just scratch it out, sign it, and mail it in. They're going to shred that. You're not negotiating that. There is an efficiency factor that the courts support with those types of blanket offers or contracts. The courts know enough about business that if we were to require for every credit card application true negotiations to occur, banks would just not offer credit cards to everybody. It'd be too much of a hassle, too much effort for too little gain at that point. Where courts will intervene is if you couple procedural unconscionability with then what is referred to as substantive unconscionability. So when both of those things intersect in a contract, courts then will entertain, either terminating the contract, voiding it, putting the parties back to the positions they were in before they entered into the contract. There's a lot of different options available to courts at that point. But substantive unconscionability, that usually concerns the actual terms of the contract. So pricing, if there is financing, interest rates, and so the terms have to be so one-sided in favor of one of the contracting parties that it just shocks the conscience of the court. So when you think of usury under the law, this idea that someone is charging a higher rate of interest than what is permitted under state law, then that is considered substantively unconscionable. There's some videos, and I won't play them because I don't know how well it'll work like in this recorded environment, but they're in the PowerPoint if you want to watch them. I have a video that talks about these payday loans, and payday loans are of an ethical concern from a legal perspective. I usually, when it's a face-to-face class, I usually have students kind of share, either personal experiences or experiences that they know of other people that have gone to these payday places. And so I don't want to mention any particular chain of these payday places, payday loan businesses, because I don't want to pick on any one. But I mean, the premise is that you need cash, and we've all seen these ads from different companies that do this. And so you go in, and usually you need to have a valid ID, and you need to have a checking account, and you need to have a job. And so if you satisfy those things, you can get an advance. Let's say it's up to $500. So they'll give you $500 today, and you write out a check for, it's usually about 10%, whatever the amount is. So if it's $500, you have to write a check to them for $550. And so, and that's usually due, the date of the check is due when you get paid next. So, 1-2 weeks, whatever the window is. So, the person coming in, they need cash. Okay, so great, I got $500 now. This is wonderful. The problem is that in 2 weeks, when they get paid again, out of their paycheck, $550 now disappears, because that goes to, that goes to the payday loan place, because you got to pay them back. You don't pay them, they're going to come after you. So now you're short again. And so a lot of times consumers, they go right back in and they say, look, I just paid this payday loan off. I need another $500. And so, again, you write out another check for $550, 2 weeks, you're in the same problem. Now, these payday places will refer to that like 10% charge as like just a processing fee. They don't label it interest. They know they cannot label it interest, because if they do that, that's usury. If imagine like twice a month you had to pay $100 to get access to $1,000, 50 each time, and you do that for the entire year, you're talking about several 100% of interest in terms of an interest rate, APR. And obviously that would be in excess of what's allowed under federal and state law. And so they cannot label it legally as interest. They can't. But when they just say it's a processing fee or like an application fee, however they want to frame it, a lot of states have said that's okay then. Now, the problem is that, well, how much do we want to try and protect people from themselves? Because that really is the issue when it comes to these payday loan places, because there are unique situations that come up. I mean, your car, needs a new transmission, or I don't know, some unusual expense comes up. You have to take your child to the doctor. So they do serve a need. There's no question about that. But, are we, kind of like giving them too much discretion there with regard to the fee that they're allowed to charge or assess for having access to these funds? Not every state allows payday loans. I know Georgia, for example, they don't do payday loans. What they have there, they have title loans. And so you have to come in with a car that you have the title to. Obviously, if you don't have the title, you can't get it. You can't get a loan. But if you have the title to your vehicle, you take that in. You basically, kind of like hand that over, and then you get whatever funds are agreed upon at that point. And again, when you pay it back with whatever their fee is, then you get your title back to the vehicle, boat, whatever it is that you're kind of like bartering there with them. So, and I've seen other states. I know besides Georgia, there are some states where they keep track of how many times a debtor goes into these payday places. They have like a database that requires updating daily by these payday loan places, and they limit the debtor to maybe like once a quarter of getting these kind of like these cash advances. Again, there's no question that these businesses are serving a need in different communities. The ethical concern is, there are people who they do it every payday. And so every payday they lose $50 to get access to $500, and they are constantly in a hole, metaphorically speaking, financially, and they're never going to get out of that cycle because in 2 weeks they're short $550 and they need another $500, and so it just is a never-ending cycle at that point. But like I said, the videos that I have there are interesting. I won't play them here, but if you have time, play them, and then you can kind of think about it and think, is there a concern there or not? As of right now, from like the state of Florida's perspective, they allow the payday loan businesses to thrive and flourish, which they do. And so, it doesn't seem to be, much of a problem here if that's what your business model is. But I think on some level, I think most can probably see the potential for abuse that can occur and how maybe we need to, there needs to be something that should be considered. I don't know, but just it's an interesting issue under the law. Definitely very interesting. So, okay. Near the end of the chapter, we talk about agreements that affect public welfare. So, again, this idea of public welfare or public policy is a vague thing. But anything obviously that's in violation of the law, that's easy. You can't do that. Some examples of illegal agreements. So I mentioned, the tort thing. Any type of illegal discrimination contracts. If you take business law 2, I briefly talked about when we cover real property, that there were many southern states after the Civil War that they wrote actually into their deeds of real estate that you could not convey this property to a non-white person. And so obviously, I mean, there's no place for that in our modern civilized world. But that's an example where if you do happen to see language like that in a deed today, which most of those have been kind of like eliminated, but it still pops up once in a while. That's not enforceable at all, nor should it have ever been. Any types of agreements for like wagers or private lotteries, so like essentially private gambling, kind of like rings that occur, which again like with anything that's illegal, you can agree to it, and if there's a problem, the parties are not going to be resolving it in court. It's going to be some other venue where justice or whatever you want to refer to it is kind of extracted. Any type of agreement injuring public service, like bribing someone for a job, or, paying a witness to not appear in a judicial proceeding. These are all just different kind of a catch-all category of things that, again, are agreements that are illegal because they violate some kind of important public policy. The last thing that I like to talk about in this chapter are agreements not to compete. And again, I like being able to discuss this in a classroom environment because a lot of students have signed agreements not to compete with different employers. And an agreement not to compete, essentially, when like you're being asked to sign this, you're agreeing that when you leave the employ of that business for some period of time in some geographic region, you're not going to compete against that company you used to work for. And so generally the law supports this. I mean, not every state does this, but a lot of states do. And when issues arise with an agreement not to compete, it usually centers on the geographic scope, sometimes duration, but usually it's geographic scope. And so I'll kind of run through a couple examples. Let's say someone is a beautician, so they do hair, that's their job. And they work for a salon, and a lot of salons do this non-compete agreement. And so, the agreement might say that, when you leave this salon, you agree not to, compete, against, this salon for a period of, let's say, 2 years within like a 5-mile radius. That's reasonable in terms of duration. That's reasonable in terms of geographic scope. Salons usually are neighborhood based. So what if a salon, with their, beauticians or hairstylists, what if they say, okay, 2 years, you're not going to compete, but I'm going to enforce a 50-mile radius. I mean, imagine if it's, let's say downtown Orlando. If you do a 50-mile bubble around Orlando, you're getting to like not quite Cocoa, and maybe you're getting towards like Lakeland, or maybe a little past Lakeland, getting close to Tampa. That's too excessive of a geographic scope, to have that be enforceable for essentially a neighborhood-based business. Change the facts a little bit. Let's say that I've had friends before that were salespersons for Anheuser-Busch, and they were based in Orange County, and so their territory was Orange County. And so, their job was to try and drum up sales for Anheuser-Busch products. So, in their non-compete agreement, 2 years, that's fine. Usually 2 to 3 years is acceptable. If you get beyond 3, there needs to be some justification, like it's a very, kind of like niche, type profession. But, let's say 2 to 3 years. And in the Anheuser-Busch example, the idea that they can't, work for a competitor within Orange County, which now we're talking about, literally, hundreds of square miles, if not thousands of square miles. That would be acceptable because that was their territory, that was their job. So if they want to leave Anheuser-Busch, and if they want to continue to work in Orange County, they got to wait 2 or 3 years, whatever the duration requirement is. Or just go outside the geographic scope. So work in Brevard or Seminole or Osceola or Lake counties for a distributor. So that's your way around it. Is that you just either wait out the duration or you go outside the geographic bubble. That's usually how non-compete agreements work. Another example where non-compete agreements will kind of come in is when you acquire a business. And so when you're buying a business from a business owner, it's not uncommon to have folded into that contract of sale for the business a non-compete clause saying that, I'm going to give you all this money to buy your business. The last thing I want is for you to show up in 2 days next door, and, kind of like opening up shop and being a competitor. So that's the other situation that can arise. Not every state recognizes non-compete agreements, and so if you see there at the bottom of the screen, Washington State, California, Nevada, Montana, North Dakota, Minnesota, Oklahoma, West Virginia, and Connecticut all do not recognize non-compete agreements for employees. So let's say you're working for a nationwide company, corporation that have locations in every state. And so let's say you start off in Florida and you sign a non-compete agreement with this company. I won't say any names, but say you just signed the non-compete agreement. And if you move to Washington State, and you're there for some period of time, and then you quit, and then you work for a competitor, that non-compete agreement is not enforceable in Washington State. It's only enforceable back in Florida, or if you're in one of the other states that it doesn't apply. So again, I always want to try and remind business law students that contracts are fairly straightforward, and most of the time they're going to be binding on the parties that enter into them. But there are parties that sometimes want to kind of push the envelope, and they will kind of exceed what they know is permitted under the law, but they hope that the other side will just say, well, it's in writing, and this company made me sign this, and so it must be legal, because they wouldn't have me sign anything that is not enforceable under the law. So if you're ever in a situation where you feel like maybe this is not a good situation, or the other party has overreached, consult an attorney, and the attorney will kind of look at the case law and look at cases that have been litigated, and they'll make a determination if you have a potential case or not. But just because you sign something does not mean that it's going to be enforceable. That's ultimately up to a judge. But anyway, I hope that helps. We'll continue our exploration of contracts into the next chapter, but I hope everyone has a good, safe, and productive week. And if you have questions, as always, please reach out to me anytime. I'll get back with you as soon as I can. But have a wonderful day, everyone. Bye-bye.